It started.
2 seconds to clock in.
How was my speed of, okay. I'm going to slow it down just a little bit.
Do you have time?
I was trying to hurry and get done.
Okay, thank you. All right, council, we're ready for our jurors?
Yes, Your Honor.
Thank you. Let's get them.
Sorry, just clock in.
All rise.
Thank you. Please be seated. Let the record reflect the presence of our jurors. Counsel, Ms. Johansson. Thank you for always being timely, jurors. We're going to continue with plaintiff's closing statements. Go ahead, sir.
Thank you, Your Honor. Welcome back from lunch. Hope you had a minute to catch your breath and digest some of what we talked about. We were at this particular slide, and I think we kind of finished with this one. We were just talking about damages from the loss of the rental property and how that should play out. And so we were talking about how to divide those damages up. Does anybody need me to go over that again? Or is that still, you're still good with that? Can I move on? Okay, then I shall. The next slide starts to deal with the commission payments that were received by the defendants alleging that they were acting essentially as real estate agents when they weren't qualified as a real estate agent. And there are two different exhibits where we found the checks that show the alleged commission payments. Exhibit 1 has 3 of them at JOH 23, 28, and 34. And then Exhibit 7 has JOH 544 and 552. And these are the 4 different rental properties. And if you add all those up, they come out to $42,960 for the 5 different commission checks. And each commission check is calculated exactly at 6% of the proceeds that were received by Gary and Donna. And as I mentioned before, they took the full 6%. They wouldn't have divided it up like you would with a buyer's broker and a seller's broker. And then even a buyer's broker splits their commission, their 3% up with a real estate agent that might represent them, and the same with the seller's broker. So even that gets divided up. So if they had been a real estate agent acting under a broker, they might have received as a commission 1.5%. Instead, they took 6%, and they weren't supposed to get any. So I mean, you can just see how far-reaching they were in terms of trying to grab money from the Johanssons. So this is exactly from, this exhibit is from Exhibit 1, and this is JOH 19. This shows the actual check that was tendered by the Johanssons through their company Garpton to Mr. Casavelli. And then on this page, this shows the second check as part of Exhibit 1, JOH 23. This is an $8,130 commission check. The third part of Exhibit 1 that shows commission payments is a $10,980 commission check for sale of the Ashwood property. And you can see clearly here in the memo section, it says sale of Ashwood. This one, Okay, this is Exhibit 1, JOH 34. This is a $7,350 commission check for Cinnabar property. And it says that right in the memo section, it says commission for Cinnabar. So you can see that Gary and Donna were actually operating under the notion that they were paying a commission for the sale of those properties. And again, it comes from their Garpton account. One of the things that we talked about early in this case was the fact that Garpton, as their company, assigned any claims it had to Gary and Donna personally. And we did that just for ease of bringing the claims here. So we gave all of Garpton's claims here. So anytime you see Garpton up there, it's just as if Donna and Gary's name is behind it. So it's their company, and if their company was paying out a commission that was not owed, then those claims now belong to Gary and Donna. So just for clarification. Here's one of the checks in Exhibit 7. This is an $8,400 check for the sale of the Granada property. And then finally, the last one out of Exhibit 7 is JOH 552. This is an $8,100 commission check for the sale of one of the two Sherrill properties. Sherrill Road had two different properties. This is the one at 10325 West Sherrill Road. So just wanted you to see the evidence that we had presented to show that those commission payments had actually been made. Here's some of the regulations and statutes regarding unlicensed persons, unlicensed real estate agents. So ARS Chapter 32 deals a lot with professions and those who have to be licensed and so forth. And ARS 32-2151.02 states there must be a written agreement to be entitled to compensation. Here there was no written agreement. ARS 32-2122B states it's unlawful to act as a real estate broker or a real estate salesperson without a license. Here the defendants were not licensed, and yet they acted as if they were a real estate salesperson. And when I say acting as a real estate salesperson, not just collecting the commission payment, they went out and marketed the property, they went out and showed the property, they went out and handled some of the closing documents and title, things like that. They took photographs of the property to advertise it. And so they really did what a real estate agent does. They even helped set the price on the house, which again is something you find commonly done by a real estate agent. And then ARS 32-2165, a person who acts as a broker or a salesperson without being licensed as prescribed by this chapter is guilty of a Class 6 felony. We're in a civil proceeding. We don't have the ability to do anything criminally, make any kind of judgment about criminal things here. But I wanted you to see that because I want you to understand how seriously the state takes this. This idea of being licensed or unlicensed as a real estate agent is very important, and they actually attach criminal penalties to it if you do that. Damages for impermissible commission payments. So the way we wanted to talk about calculating this is kind of how we calculated some of the other things. Gary and Donna want the money back. That was paid as far as commission payments. That's $42,960. Under the financial exploitation claim, Gary's half of that $42,960 should be doubled if you're gonna do statutory double damages. That would be $42,960. Under the fraud and consumer fraud claims, which you're deciding, we're asking you to roughly mimic what could be done through the financial exploitation claim. So we're looking for punitive damages under the fraud and consumer fraud claims of $42,960, in addition to returning the $42,960 that was actually taken. And then that overarching punitive damages award of $325 we built in on all the fraud and consumer fraud claims. Again, we're not going to double or triple that number. We're just saying tack that in as a way to punish the defendants and as a way to really make the Johansons completely whole. And then the damages that we seek for breach of fiduciary duty claim, Your Honor, are basically the same thing we're seeking here for the fraud and consumer fraud damages, roughly. Because I believe fiduciary duty also allows, breach of fiduciary may allow for punitive damages. I'm not sure on that. I don't have my notes in front of me. But if it does, that's what we're asking to mimic. If it doesn't have that, then we're asking, obviously, not to go for punitive damages. And then finally, we're asking for pre- and post-judgment interest on the actual damages portion. Pre- and post-judgment interest means we can start adding interest now for what's owed, but we're also asking for interest to be tacked on, like for what they didn't pay in rents for all those years. We're saying we want to add on interest dating back to that date. And then so post-judgment interest would be the date after the judgment. So we're asking for both of those. The judgment go back in time, plus go forward in time to talk about getting the judgment paid here. So if you enter a judgment of $1,000 here, we're saying that interest should start at, say, 6 or 7% from this date forward. That's post-judgment interest. If we ask for it going back in time, that would be the pre-judgment interest. So next we're going to talk about the rent that they collected on behalf of the Johanssons. And one of the things that I wanted to address with this is the fact that they were not property managers. Property managers for rental properties have to be licensed as a real estate agent. And they were not, as we talked about previously. They asserted in their closing or in their opening argument that they either were not property, I think they even admitted in their opening argument they weren't property managers. In their pleadings with the court, they did talk about the idea that they may have been, but they haven't testified to that here in front of you. But even if they denied that they were property managers or acting as property managers, what we wanted to put up here and show you was the evidence that said that they're kind of changing their tune. Back in 2015, they issued Exhibit 43, which is a new management notice from Nick Casavelli and his company Aspire LLC. And it's a little difficult to read. Maybe I can, I don't know if I can, it doesn't work on here, does it? See if I can pop that open. Nope, that didn't work. So this new management notice is dated in September 15, 2015. So this is one of the reasons we know that they started working as property managers in September of 2015. And it says this notice is to inform tenants that the management of the leased premises has been transferred. Please remit checks to the name and address listed below, and he lists Aspire. And so he's basically, and the title of this document is what? New management notice. So he's very clearly saying that he's the manager and that all issues should come to him. And that includes rental checks and so forth. So he's very clearly saying he's a manager here, even though he denies it now. And the reason he denies it now is because he knows that gets him in trouble with the Arizona Department of Real Estate for not having a license. And it also means that he's not, as a property manager, he's not allowed to collect payment. He's not allowed to be compensated if he's unlicensed. And so if there's any argument that any of the transfers that were coming out of their business account to their personal accounts was compensation, they're not entitled to it. They weren't licensed. So that money has to all be returned to the Johanssons. Not shown here is Exhibit 68. Exhibit 68 was a registrar of contractors complaint that we have one of the in which, on page 2, Mr. Casavelli says, quote, I, Nicholas Casavelli, am preparing this statement on the owner's Gary T. Johansson's behalf. Gary Johansson hired me to be his property manager for all his properties to manage and schedule maintenance or repairs on the homes as necessary. That's a flat-out admission that he was acting as a property manager, and it also says that he's not entitled to compensation because we've heard he's not a real estate agent. The other thing I want to point out on that particular excerpt is Mr. Casavelli asserted, if you remember, that there was some kind of, he thought he was a member of the Johansson's limited liability company, or he thought that they were in some kind of business partnership. I don't know if you remember that from the opening argument. But look at what he says there at the beginning of that exhibit, or the beginning of that excerpt. I, Nicholas Casavelli, am preparing the statement on the owner's behalf, Gary T. Johansson. He doesn't make himself an owner. He doesn't assert that he's a member of the LLC. And so what he told you in his opening argument that he had some business interest is completely false. You heard Donna testify that today, that they never had him part of their LLC. He was never part of a partnership with them. And there's no documentation that we have that shows it. The most that they can lay claim to is they acted as an agent under a power of attorney. That doesn't make you an owner. It just means that you're an agent to act on behalf of that company or on behalf of Donna and Gary. I'm not going to read this whole thing to you. This talks about further proof that defendants were acting as property managers. So Exhibit 12 shows all the rent payments, or shows a variety of rent payments that are coming in. Exhibit 13 shows rent payments coming in. And Exhibit 17 shows rent payments coming in. And if you remember back on Thursday, we went through a bunch of those checks that were being received by renters. And so we know that they were acting as property managers and collecting all that. So it's just proof that, again, that whether he wants to deny it or not, he was acting as a property manager. And then we talked about the proof of funds improperly taken by defendant. And it's really proof of the rents improperly taken by defendants while acting as property manager. So we showed a lot of those things in various exhibits. On this particular slide, exhibits 5, 6, and 7 were used to show a variety of transfers that were taking place from the Aspire accounts into the defendant's personal accounts. Exhibits 5, 6, and 7 are all personal accounts for the Casavellis. And this next page is going to be a little daunting. We're going to show more of those in Exhibit 13. Exhibit 13, according to our chart up here, is another personal, or pardon me, this is an Aspire account showing some of the transfers going out. And there were just a bunch of those, and we tried to detail all those for you. And then here is Exhibit 17. Exhibit 17 is another Aspire account. This is the one ending in 2077, showing transfers from the Aspire account into defendants' various other accounts. Here you see a lot of the accounts going into the 6370 account. And these are part of the transfers that we allege were never really accounted for. They were never explained. They appear to be impermissible, and they cannot be counted as compensation because they weren't licensed they weren't licensed real estate agents to manage property. And this is even more of those funds from the same exhibit number, Exhibit 17. And when you kind of work through all those numbers and all those transfers, those documents should title up, I believe, to $49,053.70. And then we have a second big number up there. That second number is adding in, if you remember, the rents that the defendants did not pay while they purported to act as property managers or while they actually acted as property managers. And that adds another $16,800 to the $49,000 number. When you add in the $16,800 to $49,053, you get that second big number there, $65,853.70. Talked about they're not entitled to compensation as property managers. Here's a statute, ARS 32-2173 requires all property management firms to have a written property management agreement signed by a broker or authorized real estate agent. No such written agreement here, and defendants are not real estate agents, nor does their company have a broker. Whoops. So how do we calculate damages for the improperly taken rents? Again, $65,000 is what was actually taken. Those are called actual damages. Then if we're going to do any punitive damages or statutory damages under the financial exploitation claim, we would take Gary's half of that $65,000 and double it. And when you take half of something and double it, you kind of arrive back at the same number. So that's another $65,853. It says 70. I think it should say 09 there. And so we want the $65,853 that is taken in return And then we want damages on top of that of $65,853.09 under the financial exploitation statute. Under the fraud and consumer fraud claims, we want to use that same number as far as being punitive damages. A punitive damages award of $65,830, I think 09 should be there, in addition to the overarching award that we talked about of $25,000, which is designed to punish defendants and help defray petitioners or plaintiffs' legal costs. And, Your Honor, again, as before, the breach of fiduciary duty claim, Gary and Donna seek the same claims as they seek under the fraud and consumer fraud claims. And we also seek pre- and post-judgment interest to the extent we're permitted that. What we showed you about the financial exploitation claim, okay, a lot of words up on the screen right now. I'm going to try and cut to the chase. And this is more for me to address the commissioner. But I think what we want you to still hear and listen and understand is that as you consider the fraud claims, we want to consider the testimony under the financial exploitation claim, because what we showed, we believe, in the financial exploitation claim is that Gary was a vulnerable adult. And that vulnerability made him easier prey for somebody who is trying to defraud you. It's like if somebody presented you a document and you were blind, you have to depend on what that person said to tell you what's in the document. And here, Gary was a vulnerable adult, and he was taking a lot of information in on the defendant, and that information was bad, and that information, that vulnerability he had, created a situation where he couldn't protect himself as well. So it made him more susceptible to fraud. So as I go through this, I just wanted to kind of have that pinging around in your head. So, Your Honor, we're asserting that Gary was a vulnerable adult at all times, relevant to each of the assets that we talked about here. In particular, I wanted to point out the testimony of our expert witness, Dr. Pamela Wilson, who opined that Gary was a vulnerable adult at least by November of 2016 and likely since October of 2015. The opposing parties have not produced any medical opinion to the contrary. Defendant's personal opinion was not expressed here other than through opening argument, but any opinion that might have been expressed in opening argument or through their pleadings that Gary was not a vulnerable adult is baseless. They are not healthcare professionals nor legal professionals and do not have any training or history that is meaningful in determining whether Gary was a vulnerable adult. You should give little or no weight to defendant's testimony or opinion as expressed through the pleadings or their opening argument. Instead, give great weight to Dr. Wilson's expert testimony from her dealing with these kinds of cases hundreds of times over a lengthy span of years. In addition, you also heard Donna's testimony of what she personally witnessed and what she and Gary endured as a result of his Lewy body dementia, which was a large part of what caused him to become a vulnerable adult. Now, Donna is not a healthcare professional either, but her testimony is still relevant as she saw the symptoms, and she could be an eyewitness to those symptoms and testify to those things, and she lived it out with him on a day-by-day basis. Second, the legislature has recognized that advanced age may itself cause an impairment when it defined incapacity to mean, quote, an impairment by reason of mental illness, mental efficacy, mental efficiency, mental disorder, physical illness, or disability, advanced age, chronic use of drugs, chronic intoxication, unquote. And that's citing to ARS 46451A5. Although this list is not included in the accompanying definition of vulnerable adult, we see no reason to exclude any of these causes of impairment when considering whether a person is impaired under that definition. That's a quote largely from the case known as Davis v. Slatos, 211 Arizona 519 at footnote number 7. The defendants were in a position of trust and confidence, and I'm going to show you some more documentations on that in just a minute. A petition of trust and confidence can arise from a confidential relationship, like they had with the Johansons. You heard Donna testify how much she trusted Nikki, viewed her as a daughter that she never had, would be in contact with her multiple times a day. They trusted them and came to believe that they were acting in their best interest when they weren't. But you can also, besides being in a confidential position, a fiduciary position will get you there as well, when you're acting as an agent under a power of attorney. Or another way you get there to be in a position of trust and confidence is to be a joint owner of property. In this case, we looked at an exhibit, one of the Johansons' accounts, I believe it was exhibit number 4, in which Mr. Cassavelli was listed as a joint owner of that particular account, and Ms. Castelli was listed as a beneficiary of that account. And being listed as a POD beneficiary or a TOD beneficiary also puts you in a position of trust and confidence. So that was conclusively proven. I think that we have pretty much demonstrated all the property that was taken from Gary while he was still alive. It was those 5 different asset classes that we've talked about. And so that puts us into the strict liability portion of the financial exploitation statute. All we have to prove is Gary was a vulnerable adult. That was established by Dr. Wilson's testimony. Then we have to prove that the people who took property were in a position of trust and confidence. That was shown by the various powers of attorney they operated under, the joint account and the TOD beneficiary. Then we have to show that they took property from the vulnerable adult that did not benefit the vulnerable adult. And we've shown that with each of the 5 different assets we're going after. Nothing that was taken from Gary was fairly compensated. He didn't get anything in return for that. In fact, and some of them, he didn't even know the property had been taken, as with the house. He didn't realize he had signed something that allowed them to record a deed saying they got the house. So we think under the financial exploitation claim, we've shown you all the elements that are necessary to make a finding that Gary was a vulnerable adult, the defendants were in a position of trust and confidence at all relevant times, and all the different property classes we're showing you, assets we're showing you, were taken from him improperly. Pardon me. Your Honor, just so I can point out that, I know I told you what the 3 elements were, but under paragraph number 5 here on my slide, ARS 46456A states in pertinent part, a person who is in a, quote, a person who's in a position of trust and confidence to a vulnerable adult shall use the vulnerable adult's assets solely for the benefit of the vulnerable adult and not for the benefit of the person who is in the position of trust and confidence to the vulnerable adult, unquote. Just wanted you to have that for reference in case you needed that. And then 46456B states what happens in this regard if a vulnerable adult is taken advantage of. It says, quote, a person who violates subsection A of this section or section 13-1802 subsection B shall be subject to actual damages and reasonable costs and attorney's fees in the civil action brought by or on behalf of a vulnerable adult, and the court may award additional damages in an amount up to 2 times the amount of the actual damages. So just wanted you to see the statute I'm drawing from, just for the record and for your identification. So the benefits that the defendants improperly took are the entirety of the $127,645.09 that Gary supposedly paid to purchase a worthless company. Then Gary's half interest in the 10124 West Ironwood property, Gary's half interest in the improper commission payments, Gary's half interest in the collected unpaid rents, and Gary's half interest in the rent payments the defendants should have paid but did not. Important testimony from Dr. Wilson about Gary being a vulnerable adult. Just want to highlight again for the court's sake some very relevant testimony. Dr. Wilson testified as follows, quote, to a high degree of neuropsychological confidence that Gary Johansson meets the criteria for vulnerable adult status under Arizona law, and moreover, that he satisfied those requirements as early as October 2016. It is likely that he met the criteria for vulnerability on November 2015 when neuropsychologist Theodore Etling, PSY, I don't know how to say that, Doctor of Psychiatry, proposed a clinical diagnosis of Lewy body dementia. So Exhibit 88 actually will show that further. That's Dr. Pamela Wilson's opinion in this matter. And then documentation putting defendants into a position of trust and confidence. So we talked about the minute entries. We talked about the bank accounts that they shared. Looking up here, we're seeing BBVA Compass bank account. This one is, I believe, Exhibit 4. I didn't put the exhibit on there. But it shows Nick Casavelli as a joint owner with Gary Johansson, and shows defendant Nicolina Castelli as a beneficiary. And we see that over on the right, where we see Gary's signature as owner, Nick's signature as owner, and then we see Nicolina Castelli listed as the agent under the power of attorney. That alone puts you into a position of trust and confidence, at least from that date. Now, this one is dated in December of 2016, I believe, but the powers of attorney go back further in time and cover the applicable periods in this matter. Here's another one that shows trust and confidence. Exhibit 23, JOH 1612. This is an affidavit and indemnification agreement for a power of attorney signed by Nick. It may not be the actual power of attorney, but it is attesting to the fact that a power of attorney exists. And the bank had Mr. Casavelli sign this form attesting to the fact that there was a power of attorney that he had shown them dating back, or this document is dated November 15th of 2016, but there's a power of attorney referred to that dates back to 2015. We have another affidavit of an indemnification agreement. This one is for, again, Nick Casavelli, but instead of being for Donna Johansson, this one's for Gary Johansson, and again testifying to the same thing, that there is a power of attorney in place. And then Exhibit 26, this is the signature page where we're showing a power of attorney from Donna Johansson signed on March 15th, 2016, naming Nick Casavelli as her agent. Next is Exhibit 100. This is at JOH 2664 to 2665. And this is Donna and Gary's joint notice of sale authorizing Nick and Nicolina to sign on their behalf in assisting with the sale of their rental properties. This was signed on April 23rd of 2016. And so this one grants a power of attorney in it. I'm going to try and double click on this. I had it all fancy set up where I could blow this up, but not this time, I guess. And then not pictured here is Exhibit 91, and we heard Donna testify about that on Thursday. Exhibit 91 shows, it was a correspondence from Nick Casavelli resigning from his capacity under a power of attorney. That document, that Exhibit 91, is dated December of 2018. So we know that he continued to operate as a power of attorney through December 1 of 2018. And you even heard some testimony from Donna where Nick tried to use that power of attorney after this litigation started to fire her attorney, me, on the basis that he was the power of attorney. And so he's acting in contravention to their best interests. They had already decided they wanted to proceed with the litigation, and an agent under a power of attorney can only do what the principal, the person who creates the power of attorney, instructs them to do. Here he knew what the principal wanted to do, and he controverted it completely. He totally violated that, and that's a breach of his fiduciary duty that he just is not allowed to do and should be held accountable for. So on the undue influence claim, Your Honor, again, this is directed towards you, since you're the one that's going to be deciding the undue influence claim. Much of the same information that we showed you under the financial exploitation claim is repeated here. Gary was susceptible to undue influence at all applicable times. One of the big differences between this and the financial exploitation claim is that under the undue influence claim, Donna was susceptible to undue influence, as testified by Dr. Wilson. Donna was not considered to be a vulnerable adult under the financial exploitation statute. So big difference there. And that's why we primarily sought double statutory damages only on Gary and not for Donna, because she was not a vulnerable adult. Just want to point that out to you. So the testimony of Dr. Pamela Wilson, she opined that Gary suffered from Lewy body dementia, making him susceptible to being unduly influenced, and that his health issues severely impacted Donna Johansson, causing her to be susceptible to being unduly influenced because she was kind of in the trenches trying to help Gary manage everything that was going on. His body was failing him at a profound level with the Lewy body dementia. And Donna here, I don't know how tall Donna is. You've got to only be 4'10" at best. She at 4'10". She is trying to help him manage his medical issues, and he doesn't even comprehend how bad his medical issues are. And she's in the trenches with him. She's up in the middle of the night when he's having his dream enactment and when he's hallucinating. She's there to help him when he falls down because his gait has been disturbed because of his issues with his hip replacement that he had. She's there to try and get him to take his medications, which he can't control and keep track of. His diabetes is out of control, and according to Dr. Wilson, it's spiking dangerously high and dangerously low. They had a lot of trouble getting it where it needed to be. And Donna's in the trenches. She is fighting to keep her husband alive as much as she possibly can. And so she is doing all that, and then asking her to also try and deal with all the financial things that were going on. She was susceptible to leaning on the defendants because they seemed to be there to help her and to support her. And you heard Donna testify that they would say, Donna, we're here for you. Well, they were here for her, but they were here for themselves too, because they weren't just there to help Donna and Gary out. They were there to help themselves to their pockets and their pocketbooks. And Donna was susceptible to undue influence at that time. And so that's another reason why we should bring those assets back into Donna Johansson and to her husband's estate. One of the elements we have to show is that there is some kind of confidential relationship. I think we did that, Your Honor, when you heard Donna's testimony and Dr. Wilson's testimony about the relationship that Donna had. We also see the fiduciary relationship that was entered into through the various powers of attorney. So I think there is enough demonstrated there to get past the element of confidential relationship. Defendants also encouraged Gary and Donna to trust them and to believe them. And they were at the point where they would listen to them above anybody else in terms of coming up with ideas or whatnot. Gary and Donna did trust them. They became dependent on the defendants and placed their explicit faith, trust, and confidence in the defendants. And this is seen by not just the powers of attorney and not just by the relationship Donna had. It's seen by Gary and Donna trusting the defendants with their medical records, with their financial records, with their tax filings, with their social security numbers, with the EIN, the employment identification number for their company, making them, and by Donna and Gary making them a joint owner of at least one of their accounts with them, and by even listing Miss Castelli as a beneficiary under a payable on death designation in that bank account. All of that shows the breadth and the extent of the confidential relationship that existed. Gary and Donna fell under the domination and control of the defendants such that Gary and Donna did anything that Nick and Nikki told them to do. Defendants concealed their actions and their intentions from Gary and Donna, especially in regard to the $127,645.09 and the 10124 West Ironwood Drive property, and the impermissible commission payments and the collected rents they failed to distribute them. All of those had an element of deception and not allowing Gary and Donna to fully understand what was going on and what the defendants were doing behind their backs. The defendants improperly and impermissibly caused Gary and Donna's and their company's assets to be transferred to the defendants' names or their control. And they did this by making fraudulent representations to Gary and Donna. They were active in procuring those transfers, as is one of the elements required under an undue influence claim. They preyed upon Gary and Donna's fears and their susceptibility to undue influence. These transfers were unreasonable in light of Gary and Donna's attitudes and family, and by doing so, the defendants breached their confidential relationship with Gary and Donna by their deceptive actions. And part of the activity that they actually showed was they prepared the purchase agreement for Aspire LLC. That wasn't something Gary and Donna prepared. That was something Nick prepared, as far as we can tell. Also, with the quitclaim deed, that was something that Gary and Donna did not prepare. You heard the testimony that Gary could not operate the computer on either one of those documents. So again, I think we fulfilled all the elements there. I believe that defendants actually, once we show certain elements of an undue influence claim, there's a burden shifting that happens. Defendants were required to show by clear and convincing evidence that the transactions with Gary and Donna were free and voluntary. And this is under the case, the estate of Shumway, 198 Arizona 323 at page 328. So that burden shifting went over to them for them to show by clear and convincing evidence that all of those transactions were fair. They did not put on any evidence, Your Honor. Accordingly, I believe that the plaintiffs can confidently state they've proven their allegations of undue influence. And the element and the benefits that they obtained under undue influence are basically the 5 different assets that we've talked about repeatedly here. Important testimony from Dr. Wilson about Gary's vulnerability and susceptibility to undue influence. This, I think, goes to the issue of undue influence, but they kind of do have some overlap. Dr. Wilson's review of Gary's medical records noted several things in 2015, the earliest date that she opined that he might be vulnerable or susceptible to undue influence. And she cited to Dr. O'Coin's recommendation for Gary to be in assisted living clear back in 2015. Gary was advised by Dr. O'Coin not to drive any further. Gary's cognitive difficulties were likely interfering with management of his diabetes and other health issues. And Donna took over medications, appointments, and finance management for she and Gary clear back to 2015. Again, this is all evidence that doctors are recording when Gary goes in to meet with them, and they're recording what Gary and the doctor are concluding together about what's going on in his life and the symptoms that are going on. Also in 2016, Dr. Wilson noted the following significant events: that in September 2016, Gary had a hospitalization for uncontrolled diabetes and debility. She also said he experienced florid, or florid is not a word I typically use, and I don't know that I can give you a dictionary definition of it, but I think it means kind of expansive or a lot. Florid hallucinations and dream enactment. He also had occasional sleep onset, visual, and perhaps tactile hallucinations. And so it's not just he's seeing things, his hallucinations got to the point where he would experience them. That the tactile means it was like he was feeling. If the hallucination if he thought he was being punched, he would actually almost feel that tactile sensation of being punched. He also reported difficulty recognizing familiar people or places, difficulty recalling events, and some functional impairment with using a phone or a computer in 2016. And so this is a period of time, 2015 is when they began managing the properties, the defendants, and they began filtering away some of the money. In 2016, you get into the middle of 2016, they start taking commission payments from the Johansons that they should never have got. And it's all while Gary's experiencing those kinds of symptoms. And then as you move on into other portions, into 2017, Dr. Wilson's review showed that it confirmed his diagnosis of a major neurocognitive disorder of some kind. and described the Lewy body dementia as being of a mild to moderate severity. So he's clearly now, the diagnosis that Dr. Etling first mentioned is being confirmed here in 2017. He has a major neurocognitive disorder. In 2017, January 2017, is when the $127,645.09 gets turned over from the Johanssons to the defendants. So you can see the progression here. As he gets sicker, they are reaching out and taking more and more money. First, it's the rent payments. Then it's the commission payments. Then we're going to go snag $127,000 in January. Then we're going to go a step further. He's so impaired, he's not getting it. Let's keep going. So in March, they come up with an idea. Let's have him sign a quitclaim deed. We'll prepare it. We'll only show him page 2. They won't even know what's going on. They are getting brazen and bolder as Gary's prognosis or his diagnosis progresses. And it's just one asset after another that they go after here. And you can see where he would be susceptible to that through this kind of timeline. Finally, in April of 2017, Dr. Wilson's review noted that Gary was suffering from increased depression and apathy and ordered the need for further diagnostic testing. Here's some testimony by Dr. Wilson herself in her exhibit number 88. She says, quote, "It's my opinion to a high degree of neuropsychological confidence that Gary T. Johansson was susceptible to undue influence and manipulation at least by November 2015, and likely as much as a year before." So she's saying the susceptibility to undue influence existed even prior to the determination of vulnerability in 2015. And it's in my professional opinion, she says, Donna Johansson was uniquely susceptible to undue influence by the Casavellis. And that opinion goes to the issue, the fact of how bad Gary was, as well as how much Donna was relying upon the Casavellis. What we showed you about the fraud claim. Okay, lots of words here. Let me take it through with you because this is something I want you to understand. So we've shown you that Gary was a vulnerable adult and susceptible to undue influence, both. That made him an easier target to be defrauded. Donna was susceptible to undue influence at all applicable times here as well, as far as what Dr. Wilson testified to. Both were elderly, both were trusting, and Casavellis took advantage of that. The defendants were in a confidential relationship with the Johanssons because of the fiduciary relationship they were acting in as agents under a power of attorney, and because Mr. Casavelli was also a joint owner of that bank account we referred to with the Johanssons, and because Ms. Castelli was named as the beneficiary. All of that puts them in a position of trusted confidence, which is part of the financial exploitation claim. But it also goes to show, again, their vulnerability and the fact that they had a lower threshold by which they could be taken advantage of, and they had a harder time protecting themselves. Defendants encouraged Gary and Donna to trust them. Gary and Donna did, in fact, trust them, and they became dependent on them and placed their explicit faith, trust, and confidence in the defendants. And number 4 is a little bit different here. Defendants caused Gary and Donna to be fearful that Gary's nephew would somehow be able to take $127,645.09. So this was something that you heard Donna testify to, that there was a nephew out there. Gary had just had some money distributed to him, and there was a nephew that Nick was saying to Gary is trying to get your money back, trying to get that money back. And that kind of was pushing Gary and Donna, that was kind of pushing Gary and Donna towards working with Nick and Nikki to protect that money, to make sure it couldn't be taken. So he was creating fear in them to drive them to a solution that he's going to provide. Convenient, is it not? Making them fearful to drive them right towards where they want them to go. They want them to turn that money over to them on the promise that this money will then be there available for them, and they'll just keep it hidden from the nephew. And oh yeah, let's put a sham transaction on top of that. So if anybody ever asks how we got hold of the money, we can say they bought our company for us. But yet they never let that money come back to the Johanssons. They never provided them equal value for that company. So it was all just Nick and Nicolina kind of driving driving them from being fearful of this possible result into something that they should have been afraid of, but they didn't know and understand because they were defrauded by the misrepresentations made by Nick and Nicolina. And they did that not only with the 127. On the next paragraph there, we talk about what happened with the house. On that one, the misrepresentations that are necessary to find fraud are the fact that they only gave them page 2, not page 1 and 2 of the quitclaim deed. So they deceived them into believing it was something else other than what it was. That's deception. That's fraud. And then beyond that, we talk about the other 5 asset classes, how the same thing, they are acting deceptively in taking the rents. They are acting deceptively by not paying their own rent and not telling Gary and Donna about that. And then you saw the exhibit that we used today, the last one we looked at, where they actually went in and constructed, or they actually forged documents in order to cover up what they had already taken. They are now doing fraud upon fraud. They are providing false documentation to show money had been paid that had never been paid. And in the pleadings and so forth, and in fact, in Nick's deposition, both the two of them have computer science degrees, and they do special effects on digital media. They can go into TV shows and movies, and they provide, like if you see a gunfire, you see the muzzle flash and that stuff, they are the ones that are providing that. They are experts at digitally altering documents, media, and so forth. So did they have the capability of creating those checks that weren't previously there? You bet they did. They took checks that were out of sequence, signed them, shrunk them down, and then put them on the same page other checks were on to make it look like this was something that the bank had produced. The whole reason we went to the bank and subpoenaed their documents was exactly to prove that point, was that on the bank records, those checks do not show up anywhere. They don't show up from the Aspire accounts. They do not show up in any of the 4 accounts that belong to the Johansons. Those checks were never tendered to the Johansons. They were never cashed. They were never paid. They were used only as a cover-up by that email. And remember, what they sent over was just partial statements. They sent over page 3 of 3 or 3 of 4, which had a picture on it. They didn't give you the whole statement. If you go back and look at the bank records related to that, you'll see how apparent the fraud is. You hold one up against the other, and they're just different. And they had the ability to do that. In regard to the property management, the defendants also deceived Gary and Donna by failing to inform them that they were not licensed as real estate agents. They didn't have an obligation to do that. To be fair, they had an obligation to tell Gary and Donna that we're not entitled to compensation to act as a property manager, and they didn't do that. Again, an omission is as bad as an outright lie, and so that again shows the fraud that's going on there. Let me see. And the fraud, we contend that the fraud extends across all 5 of the assets there. That at some point with each of those, they are making fraudulent statements or fraudulent omissions. Commission payments as well. They failed to tell them, real estate agents, they failed to tell them that they're not entitled to be paid. So I wanted to go through that on some detail on you. Let me come back to that one. Well, let me go back. So I didn't build in my consumer fraud slides separately, but everything we're saying here on the fraud claim will apply also to the consumer fraud claim, which are 2 of the 3 claims we're considering. So just everything said there works for both the fraud and consumer fraud. And then, Your Honor, the constructive fraud claim goes to you. I don't know how much I need to reiterate this, but with a constructive fraud claim, you don't actually need a fraudulent intent. One of the big differences here. It's just that if you look at the way the case law reads, if you look at it and see that the actions are such that even without fraud, it's wrong, it should be rescinded. That's what a constructive fraud claim goes to. And we believe that all the evidence we presented here does in fact show that constructive fraud claim the elements of the constructive fraud claim have been fulfilled. And I would refer you also to my unilateral pretrial statement for further discussion about that. In terms of, I'm going to move past that. Breach of fiduciary relationship claim on this slide, Your Honor, I'm probably going to pass over some of this. I just wanted to, I've been kind of addressing that as we go, and so I think you've heard some of that. But again, a fiduciary obligation, it was created under the various powers of attorney, and they blatantly breached those in how they treated the Johanssons. Instead of acting in their best interests, they took advantage of them at just about every opportunity they could. They breached that, and so they're guilty of breaching their fiduciary obligations, and we ask for damages commensurate with that. I do see here in my notes up on the screen that a breach of fiduciary duty claim can, under certain circumstances, warrant an award of punitive damages. If the defendant's conduct was gross, wanton, malicious, and/or showed spite, ill will, or reckless indifference to the Johanssons. Case law cited to there is German versus O'Leary, 145, Arizona, page 397 at 402. And we would assert that the breach of fiduciary duty claim is another legal theory which will allow for punitive damages in this matter. And as I've asserted with the jury, I would ask that a breach of fiduciary duty claim roughly track the financial exploitation double damages as a basis for determining what might be an appropriate award of punitive damages. And then just finally, Your Honor, we believe that breach of fiduciary duty covered all 5 of the big assets that we talked about here, and doesn't need to go into it too much. So I tried to do some math for you, having given all that above. I wanted to go through and just show you how each claim might play out if you agree with us on the double damages portion. I wanted to just run through that so you can have some numbers you can work with. So if you find liability against the defendants under the financial, this would be to the judge. If the judge finds, commissioner, sorry, get this right. If the commissioner finds liability against the defendants under the financial exploitation claim, then we're asking for a return of the $127,645.09 in cash, and then statutory double damages of an additional $255,290.18. Together, this totals $382,935.27. Additionally, under the financial exploitation claim, we're asking for the return of the 10124 West Ironwood Drive property, plus double damages on Gary's 1/2 interest of that property, which Donna testified was valued at $175,000, and Gary's half would be $87,500. Donna's testimony is unrefuted in that matter, and she also testified about the 5 recent residential properties they had sold, so she's familiar with prices in the area. And then the next, we would ask for a return of the impermissible commission payments plus double damages on Gary's 1/2 interest. His 1/2 interest is worth $21,480 in actual damages, and doubling that equates to another $42,960 in statutory damages. Totaling those two together equals $64,440. And then a return of Gary's half of the unaccounted for rents in the amount of $32,926.85. Adding double damages to this comes back up to $65,853.70 in double damages. You total the actual damages together with the double damages, you get $98,780.55 for this. And then payment for Gary's half of the rent that should have been made from July 2017 to present, that would equal $31,600 in actual damages, and accruing at $800 a month more until the defendants get out of the property. Adding statutory double damages of $63,200 to this comes to a total of $94,800. And then attorney's fees and costs per ARS 46456, which does allow for attorney's fees if prevailing upon a financial exploitation claim. I'm going to pause and take a breath and make sure you're.
Oh, I'm fine, you can roll.
Okay. I saw you writing furiously there. Undue influence claim. Again, this is for the commissioner on this one. If you find liability here, we don't get the double damages, we don't get the punitive damages, but we are asking for the house back. We are asking for the $127,645.09 back. We're asking for a return of the commission payments. We're asking for a return of the unaccounted for rental income that was collected, and we're asking for payment for rent that defendants should have paid from July 27th to present in the amount of $63,200, and attorney's fees and costs under 12-340-101, 12-349A, and or any other relevant statute or case law authority. Fraud claim. Back to the jury. So the simple math that I came up with is this, and I want to just to be fair, you don't have to do the financial exploitation claim does not have to award double damages. They can do actual damages of say 50,000 and then do punitive, or they can do statutory damages of 1 times that of another 50, or they can do double damages of 100. Does that make sense how that works? You don't have to do the double damages that I'm suggesting under the financial exploitation claim when you figure the punitive damages here. I suggested that the punitives should look to the financial exploitation damages as a way to how do we get to the numbers. But you're not bound by that. And indeed, the punitive damages, you can refuse to award them at all. So there's a lot of discretion you have. You also have the right to award more punitive damages than what I'm suggesting here. I just thought it kind of made sense to key it to what we're seeing with the financial exploitation claim, just because that sounds like it sounds more reasonable to me. But I just want to make that clear. So if you find liability against the defendants for fraud, then we're asking for a return of the $127,645.09. We're asking for a return of the 10124 West Ironwood Drive property. We're asking for a return of the impermissible commission payments of $42,960. We're asking for a return of the unaccounted for rents in the amount of $65,853.70. We're asking for payment for the rent defendants should have paid after they took title of the house of $63,200. And I've listed up there at $1,500 a month until they vacate, but we're just going to do $800 a month. If they stay in the house, it may take us a while to get them out if we get a judgment from you all, but we'll just seek $800 a month for future if you deem that to be fair. And then the punitive damages we're looking for come up to a total of $602,303.88. That's when, if you took the $127,000 and doubled that, if you took half of the $42,960 and doubled that, and then half of the $65,000 and doubled that, half of the $63,200 and doubled that, all those together add up in my math. And check me. I know some of you have caught me on a couple errors I've made, so please don't hesitate to check me on it. But I think it comes up to $602,303.88 on those. And then we're asking for additional punitive damages and we're suggesting $325,000 to make Gary and Donna whole for the expense of the litigation, and as a way to punish the defendants because their behavior over such a long period of time was just absolutely egregious. And then any attorney's fees that we might be entitled to under 12-340-101 and 12-340-349. You do not get to address the issue of attorney's fees. That'll be something that the commissioner will address. Okay, it'll be up to her to have us file a fee application and discuss that and lay out our basis. But I just threw that in there for kicks and giggles. Consumer fraud claim. Basically, this is a repeat of what we just looked at with the fraud claim. We're asking for the same things here. One of the things I do want to point out to you on the consumer fraud claim versus the fraud claim, the fraud claim has 9 elements you have to prove, and you have to prove all 9 of them. I think we did. I think we proved all 9 elements for each of those asset classes. But if for any reason we didn't, didn't prove it. The consumer fraud claim has fewer elements we have to prove. So if for any reason you think that the consumer fraud or the fraud claim doesn't hold up, please look to the consumer fraud claim as it has fewer elements, and we don't even have to show any kind of intent to defraud. You just have to show that the action by its nature might have caused something along that line, caused fraud. And so we're asking for the same damages in the same measure. So, and if you gave us a judgment on both fraud and consumer fraud, that would be totally fine too. You're allowed to do that. Quiet title claim. This is also something that you'll be deciding. And so we're asking on this one. This one strictly deals with the property. So we're asking for a return of the property at 10124 West Ironwood Drive in Sun City, and asking that that judgment would reflect the fact that the property should not stay with the defendants. It should instead go to the plaintiffs, Gary and Donna Johansson. And that judgment will forever bar any claim by them. And what a quiet title claim does, and this is in part of your jury instructions, it says that a claim to quiet title to a property is used to determine the rightful owner of a property when there are multiple claims. The defendants did make a quiet title claim in their pleadings, but they have not shown up to put on any evidence that they are entitled to it. On the contrary, Mr. and Mrs. Johansson have also a quiet title claim in their complaint, and they put on evidence here to show that, number one, they purchased the property originally, they paid for it completely, and it was always their property, and it was going to be used as part of their retirement income, the rents that came from that. That's a pretty compelling case to show that this property should go back to the defendants. They've also shown, or pardon me, the property should go back to Gary and Donna Johansson. And that we've also shown the documents showing how the defendants misappropriated the property away from Gary and Donna. We don't want to countenance of fraud. We don't want to let fraud be the way that people get hold of assets. And so that's another reason why the quiet title claim should go in favor of Gary and Donna. Constructive fraud claim. This goes to the bench. So, Your Honor, basically looking for the same kinds of remedies across each of the asset classes here under the constructive fraud claim. And I understand that a constructive fraud claim is really a kind of a remedy for an unjust enrichment claim. So this will tie into our unjust enrichment argument that the defendants were unjustly enriched by all the actions and transactions that took place between the defendants and the plaintiffs that have been complained of here in this matter. And we're just asking for a return of all those assets over to the plaintiffs from the defendants. I don't know that punitive damages are allowed here. I think they are. If they are, we are asking for punitive damages commensurate with what we've asked for under the financial exploitation claim. Breach of fiduciary duty, again, looking for all the 5 assets to be returned to the plaintiffs because of how grossly the defendants breached their fiduciary duties and actually used their fiduciary position to take advantage of the plaintiffs. Unjust enrichment claim, I just mentioned a moment ago along with the constructive fraud, so I won't go through that again. And then injunctive relief. Your Honor, the financial exploitation statute does allow for injunctive relief in addition to actual damages and statutory damages. And so one of the things that I thought would be appropriate here is that there would be a permanent injunction forbidding defendants from liquidating or transferring any of the assets that are at issue in this case.
And I'm sorry, Counsel, would you approach 1 moment? I believe at the beginning of the case, didn't you withdraw your conversion claim as well as injunctive relief?
I drew the separate injunctive relief claim, but injunctive relief, I did that partially because injunctive relief is allowed under the financial exploitation statute. So this is not asking you to do this as part of a separate injunctive relief. It's just part of the remedies that are entitled, the plaintiffs are entitled to under the financial exploitation statute.
Okay, thank you.
Yeah.
Go ahead, Counsel.
Now you're going to ask me to pick up right where I left off, right?
Injunctive relief, financial exploitation.
So we're looking for a permanent injunction forbidding them from liquidating or transferring any of the assets that we've been talking about in this case, except in furtherance of this court's order to return such assets to Gary and or Donna and or their company, if the court or the jury awards those assets to come back to the plaintiffs. We're also talking about a permanent injunction forbidding the use by defendants of Gary and Donna's confidential information like social security numbers, EIN numbers, confidential medical information, tax information, bank information. They've just shown a lot of ill will and spite in this matter, and we just want to have an injunctive order out there forbidding them from utilizing that in any way. And finally, a permanent injunction forbidding defendants from acquiring any assets, property, or confidential information of the plaintiffs or their company in the future. So it's a forward-looking injunction, just forbidding them from trying to obtain any of that information in the future. Declaratory judgment claim, somewhat different than the quiet title claim, Your Honor. Quiet title only looks to the house at issue, but declaratory judgment lets us talk about the other 4 assets. So anything that the quiet title claim doesn't issue, then the declaratory judgment would be something we would fall back on as well. So we want the property at 10124 West Ironwood Drive returned and a declaratory judgment for back due rent by the defendants to Gary and or their company in the amount of $63,200. We're also looking for a return of the $127,645.09, commission payments, and the collected but unpaid over rental income that we mentioned earlier. We had an equitable mortgage claim and an accounting claim, Your Honor. The equitable mortgage claim, I don't believe, is going to be necessary to talk about here based on the evidence that's been presented. The defendants aren't entitled to an equitable mortgage. They haven't presented any evidence about what that equitable mortgage amount would be. Accounting claim, we had asked for an accounting from the defendants to prove up all the money they took from the defendants or from the plaintiffs. But I don't think we're ever going to see that, to be honest. But if the court, at its pleasure, wants to consider ordering a fiduciary grade accounting, they can certainly do so. But it would be at their cost, not at the cost of the plaintiffs. I am out of words, I think. I'm out of slides, anyway. I want to thank you all. I know I went through a lot of material there. We had these ultimate legal theories that, we wanted to have them on the table to apply in case another theory didn't work. But I hope we've explained it. We hope we've connected the dots for you. Evidence is going to go back with you into the jury room, all the evidence that's been admitted. So you'll be able to verify anything I said up here and be able to kind of cross-reference it should you need to. Thank you so very much for staying with us and not letting your eyes glaze over and roll into the back of your head. I'm sure at times my droning precipitated that, and you did a great job fighting against that. Thank you so much, and Your Honor, I am done.
Thank you. The clerk will swear in the courtroom assistant and judicial assistant.
Please raise your right hand. Do you and each of you swear that you will take charge of this jury and protect the deliberations from all outside interference and communication? And when they have reached a verdict, you will bring them back into court without revealing their verdict to anyone, so help you God?
I do.
Thank you. Ladies and gentlemen of the jury, at this time I'm going to ask that you take your notebooks and you're going to go to the jury room to deliberate. If you have any questions, please contact my courtroom assistant or my judicial assistant. Go ahead.
I just want to make sure they didn't take back the demonstrative exhibits I gave them earlier.
No, I gave those to the clerk and she has those marked, obviously for future reference in the event it's needed, but it will not go back with the jurors.
Thank you, Your Honor.
I appreciate you checking. Thank you. All right, again, thank you, ladies and gentlemen, for your attention. Grab your notebooks. It's your turn to go back and deliberate now. Thank you so much.
All right.
Please be seated. Let the record reflect. The jurors are excused. We are at the courtroom with counsel and Ms. Johansson. Counsel, is there any record that you need to make at this time?
No, Your Honor.
All right. Well, you're welcome to either stay in the courthouse or go elsewhere if you like. If we have a telephone number that we could reach you at, that you could get back to the courthouse within 10, 15 minutes, we'd appreciate that. Okay. All right. Thank you. And
Is it improper for me to start cleaning up my stuff now, or?
Can I go to the bathroom now?
Yes, we're kind of free to move in.